Welcome to our Arizona Revised Statutes video library. I'm Shawnna Riggers, Managing Attorney at Arizona Family Law Attorneys. My goal is to take this somewhat dry information, make it a little bit more entertaining, and also provide you with information regarding the laws that are applicable to dissolution, parenting time, custody, child support cases here in Arizona. This is being filmed in 2023, so it's important that if you're seeing that afterwards, that you double check the statute to make sure that it is the most current version. And if you have any questions regarding any of the material, as always, please feel free to reach out to us here at Arizona Family Law Attorneys, where we provide peace of mind as there is no substitute. I'm going to read this statute and then at the end I'll discuss it. If you have questions, reach out to me directly. 25-317, Separation Agreement and Effect. To promote amicable settlement of disputes between parties to a marriage attendant on their separation, annulment, or dissolution of marriage, the parties may enter into a written separation agreement containing provisions for disposition of any property owned by either of them, maintenance of either of them, and support legal decision-making, parenting time for their children. A separation agreement may provide that its spousal maintenance terms shall not be modified. In a proceeding for dissolution of marriage, for annulment, or legal separation, the terms of the separation agreement, except those providing for the support, legal decision-making, and parenting time of children, are binding on the court unless it finds, after considering the economic circumstances of the parties and any other relevant evidence produced by the parties on their own motion or on request of the court, that the separation agreement is unfair. C. If the court finds that the separation agreement is unfair as to the disposition of property and maintenance, it may request the parties to submit a revised separation agreement or make orders for the disposition of property or maintenance. D. If the court finds that the separation agreement is not unfair as to the disposition of property or maintenance and that it is reasonable as to support legal decision-making and parenting time of the children, the separation agreement shall be set forth or incorporated by reference into the decree of dissolution, annulment, or legal separation for the parties to be ordered to perform. The separation agreement provides that the terms shall not be set forth in the decree. The decree shall identify the separation agreement as incorporated by reference and state that the court has found the terms as to property disposition and maintenance not unfair and the terms as to support legal decision-making and parenting time of the children reasonable. E. Terms of the agreement set forth or incorporated by reference in the decree are enforceable by all remedies available for enforcement of a judgment, including contempt. F. Except for terms concerning the maintenance of either party and the support, legal decision-making, or parenting time of children, entry of the decree shall thereafter preclude modification of the terms of the decree and the property settlement agreement, if any, set forth and incorporated by reference. G. Notwithstanding subsection F of this section, entry of the decree that sets forth and incorporates by reference a separation agreement that provides that its maintenance terms shall not be modified prevents the court from exercising jurisdiction to modify the decree or separation agreement regarding maintenance, including a decree entered before July of 1996. So a property settlement agreement is very clearly a binding agreement, but the court does have the independent jurisdiction to review it and make sure that it is fair and equitable, especially regarding the issues around minor children for legal decision-making, parenting time, and child support. The court always has to give their independent go-ahead on those issues because they have to make a finding that the agreement would be in the best interest of the minor children. As to property agreements, the court does need to review those clearly and make sure that they're reasonable, but that one important caveat is spousal maintenance. And so if the parties did agree that they were going to make their separation agreement and spousal maintenance non-modifiable, the court does not have the authority to go back and make changes. So whenever you're agreeing to non-modifiable spousal maintenance, you really want to make sure that that is 100% an agreement that you're willing to reach. A property separation agreement, though, is great. It can avoid very, very costly litigation and allows the parties to reach an agreement on their own terms that they believe are in their best interest and in the best interest of their minor children, which is always, always going to be my recommendation for my clients and even people who aren't my recommendation. You want to make this agreement yourself. You get to make an informed decision. You know your family, you know your kids, you know your assets, you know your needs. If you go in front of a judge, you're only going to get a few hours to tell the court every single thing about your entire family. And that probably isn't enough time. You have to make the most of that time. And so by entering into a separation agreement, you're taking a lot of risk out of the dissolution process.